Tariff news today. A comment window just closed. A 50% tariff on Canadian goods. We all know that's going to be happening on August 19th. And the forced labor tariff just picked up another lawsuit. Look, at least one of those three is sitting on your to-do list right now, whether you know it yet or not. Here's what's confirmed, what's still proposed, and what to do about each one. One note on vocabulary before we start, because it changes what you actually do with each story. Confirmed means a proclamation is signed, a rule is final, or a rate is already in effect. It belongs in your cost model today. When I say active investigation, that means comments are open, a hearing is scheduled, or a case is in litigation. Nothing final yet. It belongs on a watch list, not in your model, like on the 90-day tariff risk calendar that I'll talk to you about a little bit later. Expired means collection has stopped, but there can still be a live refund question behind it. Now, that's very important, and I'll flag which one is which every single time. I'm Ramie Virk, procurement leader, trade and tariff risk strategist, subject matter expert, 20 plus years in supply chain, founder of Career Chronicles, and creator of the Tariff operating system. Every date you hear is an actual calendar date. So whether you're listening on the day this drops or 3 weeks later, you can check what I say against your own calendar and know exactly where you stand. Now, I mentioned the 90-day tariff risk calendar. It was basically rebuilt again to show the rolling 3-month window. So now the most current version does show, I believe it's August through November. So you should be able to go ahead and pull that up. If you don't have it, you can always go ahead and download it. It is in the link below, and it'll help today to match what's on your screen. Segment 1, Germany Pharmaceutical Section 301. The deadline, August 10th at 11:59 p.m. So this is an active investigation. USTR is investigating whether Germany's pharmaceutical pricing practices are unfairly burdening U.S. commerce. Now, with that, the entire public hearing is set for September 22nd. So the only thing that you need to note for anything right now is to go ahead and put that date down, because obviously the written comments and hearing requests and testimony summaries, they were all due on August 10th, 2026. Now, no tariff has been imposed, so no rate, product list, any of that. This is just a comment window, not a duty. Now, if you've got German pharmaceutical exposure, that's including finished drugs, APIs, recipients, packaging, cold chain, finish mapping it before the window closes. Simple as that. And keep this separate from the Section 232 pharmaceutical tariff already in effect. Those are two different authorities, two different rows in your tracker. So if you decide to go ahead and use the calendar that I'm giving you that's free in the link below, just know that I've already loaded all the Germany dates and all that, so you don't have to do anything else. Otherwise, go ahead and put it in your own calendar, so that way then you can be set up for this. Segment number 2. This is the forced labor Section 301. The rates are now official. Now, this one is confirmed. Remember, I told you that I will let you know when it's confirmed. The Section 301 forced labor action covering 60 economies has been effective since July 24th. We all know that. It's now formally published in the Federal Register with CBP implementation guidance behind it. Now, I've already got all these rates and everything as far as this is concerned, uploaded and updated in my tariff autofill export. Otherwise, wherever you get it from, or if you just want to go onto USTR or CBP, you can get it all there. Now, I just want to go ahead and add a couple things that I just want to make sure that I capture. Okay. Now, as far as U.S. Customs and Border Protection, that's CBP, that's where you go. They've already got the filing guidance for these new additional duties covering roughly 99.4% of the U.S. imports. If I have not said that before, I'm going to say it now. Now, these are the key details of the action. Obviously, it was effective date with July 24, 2026. That means that you have to make sure all of your paperwork has that information on there. There was an actual guidance as far as the transit rule, the cargo that was already at sea prior to the effective date. So if you have that paperwork, you need to make sure that you have everything aligned. So that way, then you can make sure that you don't get charged after the fact. If you're like me, you've dealt with this before, where AP comes to you, especially the last year and a half. I mean, I've had it happen to me, gosh, multiple times in the past 20 years. So I just want to go ahead and say that. Like, I'm going to say hundreds of times in the last 20 years. This is not a new thing. You can get billed after the fact, because what happens is that while everything's being put into the system, while everything's happening, sometimes you won't get the full bill whenever you import your goods. Let's just leave it at that. I don't want to go into all the specifics there. But what can happen is that later down the line, I know from my own experience, we all know Liberation Day happened on April 2nd, but I got bills from March and February of last year in 2025 saying that we owed for those tariffs, and we had all the paperwork to combat that. So that's where I'm going here. So you need to make sure, because there was a special provision and exceptions rule, you need to make sure that all of your paperwork is absolutely documented correctly, because there may be a way for you to save thousands, if not hundreds of thousands, if at that time you fall under that. So if you had items that were coming in July 24th, prior to or a little bit after, just make sure that you have all of your documentation. It's really easy to go ahead and do. If you have any questions, you can go ahead and send me a message. But I also have listed this on a previous podcast. But obviously, what I'm telling you is very simple. Just make sure that you have all of your paperwork in order. Again, I just want to make sure that you understand that CBP guidance, CBP instructor trade teams via CSMS number 693-26983 regarding Chapter 99 HTSUS headings and entry filing procedures. So there is information for you to go ahead and look up if you'd like to. Understand, under the special provisions and exceptions, there are textile quotas. Provisions were outlined to establish tariff rate quotas as TRQs for specific apparel and textile inputs from economies like Bangladesh, Cambodia, Indonesia, and Malaysia, all linked to U.S. cotton imports. Just want to make sure that we all understand what those special provisions are and where the exceptions are. Most companies land at 12.5%. Now, if you look at all the tariff rates tab, I'll go ahead and include it on screen. Most economies land at 12.5%. There's 17, which are Canada, Mexico, India, Indonesia, the UK, and others. They land at 10%. The EU, Taiwan, Japan, South Korea, and Switzerland, they all get a rate that's set for net of their existing MFN tariff. There is a general exemption list. It's civil, aircraft, pharmaceuticals, steel, aluminum, copper, autos, wood, semiconductors, in-transit goods. There's humanitarian donations that are also included, plus 11 country-specific carve-outs. If your rate lookup and your Chapter 99 reporting sequence were built on an earlier working assumption, confirm now that they match the published notice before your next filing. The Tariff Autofill Tools country group and exemption logic is already refreshed for all of this. So instead of you having to do all the work, you can actually just get that. It's also going to be listed in the link below. Segment number 3. I'm going to briefly cover this. I'm not going to go too much into it, but I am going to go ahead and just briefly cover it so you can put it into your calendar. There are 3 active litigations as of right now. And as far as everything is concerned, again, this is just active litigation to put on your calendar. As far as what they're arguing and all that's going down, we already know that the tariff structure that the courts already struck down twice, once under IEEPA and once under Section 122. This time it's for a third legal theory. Who knows whether it's going to go through or not, but we just want to go ahead and put that down. On August 3rd, a coalition of 25 states, and I'm not going to repeat all the states. You can look that up if you want. They've also went ahead and filed a third suit. Now, there's no hearing date that's set in any of these. There's no injunction. The duties stay in effect and stay collectible while this all plays out. All we want to do right now is to make sure that you document everything and that you still understand you have to pay these tariffs. As far as I'm concerned, the courts can eventually overturn a tariff, but they cannot hand you a refund on any entry you didn't document. This is a procurement action. Keep your litigation register current. Entry number, Chapter 99 code, duty paid, protest deadline, across all of these cases, not after a ruling. That's exactly the kind of documentation the tariff refund suite is built to keep ready. And what's great about that is it's auto-generated, so that way you don't have to continue doing data entry where you can make mistakes. If you're interested in that, you can see the link below. Otherwise, if you already have your own system, this is not a hard sell. It's just letting you know what I use Everything that I'm mentioning as far as all the procurement actions or whatever, the reason why I mention them is because this is the system that I built for myself that I use daily. I've been doing this for over 20 years, and I've already built this system. It is automated, so it makes a lot of things a lot easier, and that's what we need right now because you don't need more hands touching it while we have to go through it. So that's why I mention it. I do ask one thing. If you're finding these useful, the fastest way to keep getting them is to hit follow or subscribe, depending on where you're listening to this. It's basically free. Segment 4, UFLPA, also known as the UGAR Forced Labor Prevention Act. It basically listed 43 more companies, so there's now a total of 187. Now, this is a confirmed action, and if you haven't rescreened since August 3rd, your last screening is already stale. And just so you know, this is a U.S. law enacted in 2021 that bans goods from the Xinjiang region of China or from blacklisted companies, assuming they used forced labor unless proven otherwise. So in DHS, when they added 43 companies to that list, that's effective July 31st, it's the largest single expansion since the list existed, bringing it to a total of 187. Now, CBP has been applying the rebuttal presumption against those entities since August 3rd. Goods sourced from the listed entity are presumed made with forced labor and barred from entry unless you can prove otherwise with clear and convincing evidence. Now, one distinction that trips people up is this is not the same control as the forced labor tariff from segment 2. Now, one thing that trips people up is this is not the same control as the Section 301 forced labor tariff. Now, paying that 10 or 12.5% in duty does not make a shipment from UFLPA compliant. So, this is two separate legal tests, two separate reviews. Now, this is your action that you need to take into effect. Rescreen your direct suppliers and your tier 2 and tier 3 suppliers against the updated 187 entity list and flag any match for a real sourcing review, not a note in a file. Now, the supplier risk alert system inside the Tariff Impact Automation Suite is built to flag exactly this kind of update against your own vendor records automatically. Segment number 5, Canada Section 338. Again, that starts on August 19th. It's 50% and USMCA doesn't save you. Now, this is a confirmed future action, and this is a big one. There's an additional 50% duty on specified Canadian dairy, motor vehicle, and alcoholic beverage products, roughly $20 billion of trade. If you want all the information, again, this takes effect on August 19th at 12:01 a.m. Eastern. I do have the specifics. Again, just click the link below. Now, this is the first presidential use of Section 338. So as of right now, there are not any implementing regulations that exist as of yet. And there's no judicial precedent that exists yet. And here's the part that you really need to be catching right now. It even applies to goods that otherwise qualify as USMCA originating. Now, being USMCA qualified does not automatically protect a covered product from this tariff. Now, Canada and US are still talking. These are the actual categories: automobiles, dairy quota, alcohol access, relief on existing steel and aluminum tariffs, but nothing is legally suspended. Now, negotiation headlines are not customs relief, so you need to understand that. It's only a proclamation. The only thing that actually moves this further is if there's a CBP implementation change. Now, this is your action. Keep the 50% in your base case forecast. And if your Canadian SKU level exposure file isn't finished, you need to finish it as soon as possible. The new Section 338 overlay, that's the 50% with no USMCA exemption. It's already built into the tariff autofill tool that I'll link it below, but it's basically the tool that's covered for all the Canadian HDS lines. So I've already included all of that in there. Segment 6, Quartz service products. Now, this is a 4-year safeguard tariff rate quota on all Quartz surface products that takes effect on August 15th at 12:01 a.m. Eastern. The HTS code 9903.45.30 is the quota goods that you need to be using. It's also over quota goods with the HTS code 9903.45.31. Now, if you want, you can take these HTS codes over to my live tracker and actually plug them in and actually see what's happening right now. Now, you'll see where they are currently. If you've got Quartz surface orders entering on or after August 15th, you need to validate your HTS classification. This is a procurement action I'm telling you to take. You need to make sure you validate your HTS classification, legal origin, excluded country eligibility, and quota treatments now. Don't let a supplier's description of engineered stone settle that question for you. Again, the scenario planner inside the Tariff Impact Automation Suite models in quota versus over quota exposure before that line lands. That's very important for you to know for your budgeting and for you to adjust any forecast you have coming up. Again, if you're dealing with FIDs or AFEs, this is super important. Segment 7, Section 232 metals, 14 new derivative articles are on the table. Now, this is an active investigation. Comment window is going to be open all the way through August 27th. Now, BIS. BIS stands for the Bureau of Industry and Security. It's an agency within the U.S. Department of Commerce. It's important because it administers and enforces trade regulation, including the proposing and managing national security import tariffs under Section 232, which is the trade expansion of the Act of 1962, which is how these tariffs are actually in place right now. Again, I just kind of trailed off. Sorry. I'm giving you information that you probably know, or if you didn't. But BIS has proposed added 14 derivative articles to the existing Section 232 aluminum, steel, and copper tariffs. That's why this is important. Things like welding machine parts, fire extinguishers, cranes, trailers, and filled steel containers. Now, most proposed items sit at like 25%. Cranes, lifts, and trailers sit at 15%. If you're in construction, if you're in building, if you are doing turnarounds for the manufacturing industry or the oil and gas industry, this hits you because it affects the people that you contract for cranes, lifts, and trailers. I mean, there's so many things that this actually affects. There's no hearing date yet, and this is a proposal. It's not a final rule. Again, it's in my calendar. If your supply chain touches any of those categories, start the supplier conversation now rather than waiting for a final rule that will likely land in the fourth quarter. Now, the Tariff Playbook Suite Supplier Outreach Tracker is built to flag exactly this kind of exposure ahead of comment deadline. So these are actual heavy equipment operators that are going to be needing this. Segment number 8, Polysilicon. This is a minimum import price program. It's confirmed for December 4th. Now, this is confirmed. Basically, a rumor on August 4th, a signed proclamation 2 days later, and then all of a sudden, polysilicon ingots and wafers, solar cells, and solar modules all get a minimum import price floor plus a 15% tariff on downstream derivatives, and that's effective December 4th. There is a reduced combined rate for Japan, South Korea, Taiwan, Switzerland, the EU, and Liechtenstein, and a 10% rate for the UK. Okay, here is the procurement action that I'm letting you know. Do not model this as a 15% added to today's invoice. Build 3 separate numbers: your current price, the minimum price floor, and the floor plus the tariff for every polysilicon linked product you buy. Now, I've already got this all set up for the scenario planner, which it handles that layering before it even hits your books in December. Again, I'm going to continue talking about what I use. If you've already got a tariff operating system or something similar where you track this is just me telling you how you should be doing it. That's why I'm giving you my procurement action. And then I'm giving you what I do. Segment number 9, IEEPA refunds crossed roughly $100 billion. Now, this is active refund processing, and the number just stopped being theoretical. A court filing dated August 5th shows CBP has paid out roughly $100 billion. Now, that's of the approximately $166 billion that's already been collected under the IEEPA tariffs that the Supreme Court invalidated. Kate Phase 3 is processing finally liquidated entries tied to the individual court plaintiffs. Now, this is an accurate statement. I know we kept on hearing when Kate Phase 2 was going live, and obviously it is live now, but I need you to understand that Kate Phase 3 is designed specifically to handle refunds for finally liquidated entries. So those are over 80 days past liquidation. But it is strictly restricted to importers who have filed individual lawsuits in the Court of International Trade. So please understand that there's a distinction there. All right. Now, if you haven't filed suit yourself, there still isn't any confirmed refund path outside a class proceeding. So if you're sitting on entries approaching their 180-day protest window, that's worth evaluating as soon as possible rather than waiting. The refund opportunities tab in the free 90-day tariff risk calendar is already structured to hold for this. And if you don't have it, I do have a complete tariff refund suite. I'll leave the link below, but you can see how my actual tariff refund suite actually generates the documents, and so you don't have to worry about errors. Now, segment number 10, Section 122 confirmed expired. The appeal is still alive. Okay, I'm going to go ahead and give you a little bit more of an explanation on this. Okay, when I say it's expired, it's not closed. The 10% Section 122 global surcharge expired on its own statutory 150-day clock on July 24th. The same moment that forced labor Section 301 tariffs took its place. Remember, that's like 99% of goods that are being imported. CBP is not currently collecting it, but the Federal Circuit appeal over whether it was lawful in the first place is still open, and there is no ruling date set. Basically, if that appeal ultimately says, yes, it was unlawful, entries that pay the surcharge between February 24th all the way to July 24th may have a refund path. Now, this is the action item that I'm going to give you. Confirm your current rate lookup and make sure that there's no active Section 122 line. Make sure you're not paying that. And log that February to July window as a contingent refund watch item, not a closed book. Now, segment number 11. Now, I'm just going to go over this really quickly because it's not a done deal. This is active. Now, the Senate did pass the Sanctioning Russia and Iran Act on August 7th. It would authorize tariffs up to 100% on major buyers of Russian oil and gas. Now, there is a waiver authority for the president. It has not passed the House. The House returns from recess, and they could take it up then. Now, this is your action item. You need to go ahead and keep that 100% number out of your approved landed cost baseline for now. But if you've got India or China exposure with Russian energy angle, that's worth a scenario model ahead of the House action, not after it. Now, what I'm going to tell you to do is I'm going to tell you to go ahead and put it on your calendar, obviously on your tariff risk calendar. It is a multi-outcome modeling for a tariff that doesn't exist yet, but could move fast once the House acts. It's exactly what the tariff scenario strategy kit is for. I'm going to go ahead and tell you to put it on your calendar, and I'm not going to tell you to go ahead and start modeling it on anything yet. We know that we should possibly start doing this, but things change so fast. And even though it's already passed, it still has some hurdles that need to go through. I'd rather start acting on it once we know that it actually passes the House. That's my strategy. Now, segment number 12. USTR is building a border adjusting critical minerals framework. Now, this is active and very early. It's a policy statement. It's not a tariff. So you're going to put this on your calendar. USTR welcomed new pricing benchmarks for gallium, germanium, tungsten, antimony, and neodymium and praseodymium. I butchered the last two. I'm sorry. I always have a hard time with any meums. Now, this is groundwork for a proposed agreement on trade in critical minerals. It is not a currently imposed charge. Now, this is your procurement action. You need to add it to your critical mineral policy monitoring and sourcing scenarios. No rate table change is warranted from this alone yet. Now, this is exactly the kind of cross-program, cross-agreement risk the Strategic Command Suite is built for, to hold in one place instead of scattered across separate trackers. All right, we're going to go ahead and do a quick flyby. We're going to call it quick hits. So let me go ahead and tell you what we have going on after this, because I can keep on going down each segment, but it will take me hours to get through everything. So there's a handful more worth a line each. Full detail on every one of these is at careerchronicles.org. The link is below for everything from this post, as well as everything that's happened from July 30th all the way to August 10th. The AGOA and Haiti Hope Help retroactive refund window, that one did close on August 2nd. So if you had qualifying entry and didn't file, that specific window is gone. You need to route anything left over through standard protest timelines instead. Sorry if you missed it. CBP now requires electronic-only payment for post-summary corrections. Again, CBP now requires electronic-only payment for PSC, effective August 5th. There's no more checks or cash, and partial payments are not accepted. Now, confirm ACH enrollment is in place before your next PSC. Now, Section 232 pharmaceutical rates got more specific. Japan, the EU, South Korea, Switzerland, and Liechtenstein are all confirmed at 15%. The UK is still at 0. And separately, the generic pharmaceutical 0% window has been live since August 1st. There's nothing to adjust there today. Just know it steps up in 2028, again in 2029. Now, if you're leaning on China's Section 301 exclusion, mark your calendar for November 10th. That's where 178 of them expire. Now, this is worth a quick check against a free HTS rate lookup before you build next year's forecast, assuming that exclusion will still hold. And 2 ongoing investigations. The free HTS rate lookup tool, I'll go ahead and link it below. It's free. You can just go to it. It's live. And there's 2 ongoing investigations worth keeping on your radar without touching your cost model yet. Now, this is a procurement action, so put it on your calendar. This is a structural access capacity investigation across 16 economies and Vietnam's intellectual property Section 301 case. Now, neither one has a final rate. Both could matter later, especially if you've shifted course into any of those countries specifically to dodge a different tariff. Okay, I know that was a lot, so here we go. Every story you heard today, full tracker fields, exact tabs, how I actually do everything I'm talking about so you can see it, is written up in full at careerchronicles.org. The link is below. If refund recovery and protecting what you've already paid is where your head's at after today, that's exactly what the Tariff Refund Suite is built for. 4 trackers, a filing pack generator. It basically has 4 trackers, a filing pack generator, so no more manual entering and making those mistakes, and CAPE submission prep, all in one place. You don't need mine specifically. The ROI is yours to figure out. If you're finding these useful, I'm going to ask you, this is completely free to you, and it helps me out a lot, is you hit subscribe wherever you're listening. It's the same feed. In the next episode, I'll have a little bit more on a few other things that we're going to go ahead and do a deep dive into. I'm Ramie Virk. I'll talk to you next time.